disciplines can't have sort of a background role, but it has to be recognised with philosophy or sociology or history, same thing. They're being transformed and used actually for an improper purpose. There is just, I can see cues of people wanting to talk.
So maybe we should all of us try to be very succinct, and so Will and then Barry, and then we'll get some response.
What was the decision rule about the mics there? I was just curious. I'm kidding.
The left always takes precedence.
Stage left.
So I know this is a panel about constitutional law, but I have a question that would help me understand the sort of historical position about a different kind of law, property law. So in property law, frequently current ownership turns on past facts. There's a doctrine called nemo dat that often means you can't give what you don't have, and so to figure out who owns something, you have to look backwards and see who owned things as a legal matter at various times in the past. So my question is, when that happens, as it does in American courts, and you need to figure out who owned the Old Dominion Boat Club in 1789 or 1848 or Blackacre, who owned something 150 years ago, is that a question that historians can answer? Is that a question lawyers can answer? Is that a question nobody can answer? How do we think about that kind of historical legal question?
Barry, why don't you ask, and then we'll respond to both if we can.
Very different direction.
Okay, well then quickly. I'm not sure who that's directed to.
Well,
but
I can give a one-line answer, and then I'm happy for others to fill it out. But the answer is, sure, that's in the historical record, but the record of the past is not the same as history.
So
Historians may know where to look, but that's not doing history to come up with the answer, looking through the old property records to come up with the answer whose name was on the title back in whenever. That's not doing history. It is in the Torrens title system in Australia. Indefeasibility of title.
So I have a question mostly for Helen, though I have to start by just asking Saul because I'm just curious. So the new originalism, does anybody else take that to be ironic, or is it just me? But anyway, so Helen, I'm just curious about accepting your views about history and understanding that I'm not about to talk about originalism at all. Do you think that history can be used, if the task of the judge, this is going to be controversial, but if the task of the judge was to figure out in interpreting the Constitution what's constitutive of us, can history play a role there in terms of understanding who we are? Because you sort of do this formal leap to law, and it seems to me that there's a role for history that isn't originalist history. It's just history, who we are.
I don't really understand, in a sense, the distinction you're making between history and originalist history.